So let me introduce my all-star panel. To my immediate left, Rolin Bissell, a partner at Young Conaway in Delaware. To his left, Gary Bornstein of Cravath, and to his left, you've already seen the great Corinne Amato from Prickett Jones. So we are going to go through at least 4 topics of sort of key Delaware developments over the last 12 months, and we will kick it off with Gary talking about oversight duties for officers and the McDonald's cases.
Great, thanks, Blake. I hope this is working and you all can hear me. Good. Oh, okay, I'm going to stay away. First, I should just say before I talk about McDonald's, as after hearing the Chief Justices, maybe I'm the only non-Delaware person in the room. So I thank Blake and the Center for the invitation as the New Yorker, or more accurately, the Connecticut person who's come to join you. So I, too, am from one of the at least smaller states geographically. So thank you for having me here. I'm going to talk mostly about the McDonald's case, which many of you probably are familiar with. I view McDonald's as one of the cases that has gotten the most press for the most obvious principle of law, or at least one that should be or should have been surprising, not have been surprising before it was, the decision was actually issued. A few moments just for those of you who aren't familiar with the facts and the rationale for the case. The facts are actually relatively egregious, where there was allegedly, I will treat this from the perspective of the motion to dismiss standard, there was allegedly a relatively inappropriate party culture at the McDonald's headquarters. There were acts of sexual harassment allegedly committed by the chief human resources officer. There were congressional investigations regarding the issue. There were labor strikes regarding the issue. There were other regulatory inquiries regarding the issue. There had been internal discipline on the subject, all of which brought the company to the face of what we were just talking about earlier with the Chief Justices, of an oversight issue and a Caremark-style claim against the directors, which was relatively conventional as a legal matter, but also against, among others, the Chief Human Resources Officer, raising the question, do officers who are not directors owe the same type of oversight and care duties as the directors have traditionally done under Caremark? Vice Chancellor Laster gave a resounding yes to that question, which, as I say, should not have come as a real surprise. The Vice Chancellor pointed out in his opinion that there had not actually been a decision in Delaware that quite so squarely made the point, which was one of the issues that had been joined in the briefs. If this were such an obvious proposition, why had it not actually been articulated before by a Delaware court? The Vice Chancellor gave a couple of reasons why he thought that was, which are interesting for those who want to take a look at the opinion. But in the interest of time, I'll talk about the reasons that he actually articulated supporting the rule. One is that it's just a natural outgrowth of the rationale underlying Caremark. The seriousness with which officers and directors are supposed to take their responsibilities to stockholders, their obligation to monitor what's happening at the company, their obligation to make sure that there are compliance systems in place to ensure the company remains in compliance with applicable laws that govern the company's business. I think about Chief Justice Strine's observations a few minutes ago about the ice cream case, for example. Vice Chancellor Laster also pointed out that there are cases, Gantler being one of them from the Supreme Court, that identify an equality of duties between officers and directors. In other words, if directors have this duty, we would expect officers to have it as well, just like we expect officers to have comparable duties of loyalty that directors have. There are two other ones that actually, to me, are a little bit more interesting, which supported the Vice Chancellor's rationale in McDonald's. One, that officers have responsibilities as agents. And agents traditionally, even outside of the corporate law, just as a matter of common law all around the country, agents have duties that they owe to their principals. Why not a duty of care? And the last one that he referred to is accountability to the board. Officers have a responsibility to bubble up, to surface up to the board, who's not involved in the day-to-day management of the company usually, have an obligation to bubble up and surface to them issues that require the attention of the board. And this is part of the duty they have to build those systems and to identify red flags so that the board can act on them if necessary. So as a result of all that, we reach, again, as I say, a relatively unsurprising conclusion that officers do owe these duties. Stepping aside from the doctrine and the case, I can tell you as a practitioner and as someone who regularly advises companies and who is in the business in part of informing my clients about developments in Delaware law, this one got real attention. Why? Well, because it got people thinking about their own personal liability who maybe hadn't been thinking about it in quite the same way before. So I had a number of conversations with people who were asking, does this put me in the crosshairs in a way that I previously had not been? And I hasten to say, all of these people, I mean, the vast majority of clients that I talk to about this, but vast majority of clients that I deal with generally, are people who, to use a word that Chief Justice Steele didn't like in the prior context, people of good faith, right, who really take very seriously their responsibility to steward the corporation in the right direction, do what they can for their stockholders. And so they're worried about liability, not because they're concerned that they're doing something wrong, but because they might get tagged for having done the best they could, taking risks that they're really required to take if they're discharging their responsibility to the company, making tough calls, business judgment. So how did I deal with that as a practical matter? There are three things. One is to point to the fact that it is a bad faith standard that does get articulated in McDonald's. People who are trying to do the right thing and come out with new Coke, right? They may have made a bad decision, but they're not going to get tagged under this standard. The second is to point out that these are derivative claims. And so there is a real obstacle between an aggrieved stockholder and an officer, which is the board. And the board, in the first instance, has the duty and the power to decide on behalf of the corporation whether to pursue a claim against the officer, not a stockholder, even a group of stockholders or stockholders' council. And it will be the rare circumstance, I believe, where a board will not be capable of assessing a demand, in which case it should be the rare circumstance where a claim like this can go forward. And the last point that I'll make before turning over the microphone back to Blake, or inviting others to comment, is this bore out in reality, in the sense that there's a second McDonald's opinion in which the Vice Chancellor dismissed the claims against the members of the board because although there were red flags, the pleading stage inference was appropriate to conclude that they had acted on them in a way that they had discharged their duties. And that opinion was of characteristic length from the Vice Chancellor, but there was the same day a two-page order that dismissed the claim against the officer because the derivative standard had not been satisfied. So that too, as soon as that one came out, discharging my responsibility to my clients, all the people who I sent the first opinion, I then sent the second opinion and had a number of easier phone conversations with the same group of people.
And so because of the way that the different aspects of what was essentially one motion to dismiss argument came out. What is the practical effect? I mean, so the actual effect in the litigation is a lot of dust, but really essentially just dismissed. So what is the practical effect of having this officer opinion out there, even though it didn't, in a sense, mean anything in the litigation?
People pay attention to what gets said in the Chancery Court. And so there was an outcome in this particular litigation, but I think as evidenced by the conversations that I had, and I know a number of my colleagues and others at other firms have had with clients, it had a real impact in the world in terms of people thinking about what their responsibilities were. And how concretely do I think it will have an impact? I think it will have an impact in how people think about the systems that they generate internally for identifying the red flags. I think people will be paying more attention to that. And also, I think they will be paying more attention, and I've seen this, people pay more attention to the definition of their roles within the company. Because one of the things that is discussed in the opinion is how you have to, as an officer, pay attention to red flags that are in your lane, things that are within your remit as an officer, unless they're really egregious, in which case, anybody has to pay attention to them. And so people are thinking a little bit more about, well, what is my lane? What is my remit? What are the red flags that, would come to me rather than to somebody else in the C-suite or elsewhere in the company? And I've seen that be a topic of discussion as a result of the opinion.
Well, it brings up another interesting issue, which is, as a litigator, when we think of officers, we tend to think of the officers who are subject to jurisdiction under 3114. So anybody with a C, that starts their title, or the top 5 most highly compensated officers in a public company. But this opinion is not limited to 3114 officers. So, really, it can have a more significant effect to people who we don't think of as litigators, as folks who are subject to jurisdiction in Delaware.
I agree. I mean, that's one of the things, by the way, that the Vice Chancellor mentioned about why this hasn't, maybe an explanation for why this hasn't come up before. It's only been 20-ish years that there's been presumed jurisdiction for those folks, although that does feel like a long time to me.
Yeah, when you say it.
Right. But I think you're right that there is an ambiguity there. In some sense, it's an ambiguity that we see in other areas of the law, like in Rule 32, in the federal rules at least. I don't know if it's quite the same in Delaware, where an officer's deposition can bind the company or be used at trial for that purpose. You wonder, well, is this person sufficiently senior to be an officer or not? This is probably more significant of an ambiguity. One of the clues in the opinion, the things that I sort of thought about as more interesting, is this rationale on accountability to the board. And so I would think, in order for an officer or someone to be an officer for purposes of this opinion, you would need to be somebody who interacts with the board, who's responsible in some sense for making sure that the board is getting the information it needs, which may be somebody with a C in their title. It may be functionally somebody else. But I think somebody who's deeper down in the organization really shouldn't be tagged with that kind of responsibility. They have responsibilities as an employee to the company, but extending that to the stockholders without their sort of being intermediated with the board, I think would be a step too far.
Yeah, there's a lot in the opinion, Gary, and I'm just curious, you were just touching upon its discussion about how certain officers may have to have more intense focus on things that are in their line of duties, like the safety person better be really spun up on safety, and maybe the CFO better be on top of finance. And there's some discussion of the often forgotten part of Section 141 of the Delaware General Corporation Law, subsection 141E, which is a director's ability to rely on officers and agents and others. Does the more intense focus the officers have to put on oversight, does that create any offsetting benefit for the directors? Can they, if they know they've got or believe they have a decent officer in place who's doing his or her job, can the director then sort of say, well, my oversight job just got a lot easier because it's this person's job to really be focused on this, and they're in place and I'm relying on them?
I would say a director could do that if they were interested in taking on a lot of risk and finding themselves with less of a chance of prevailing on a motion to dismiss. I think that would be very dangerous. The directors have the responsibilities that they have. They can rely in good faith, certainly, on whether it's experts in the field, their lawyers and bankers, whether it's their officers. But speaking as someone even who is typically defense counsel in cases like these, I think an argument that said, well, I took my foot off the gas because I was told that my chief human resources or chief financial officer now bore the risk of direct liability under McDonald's would not be a terribly appealing position for a director to take.
So one last sort of question on this. We see, at least at McDonald's, that demand futility may not be a profitable way to address these issues through litigation. So what does that mean? Do you see an explosion in the use of stockholder demands to address these issues?
So at the risk of being derelict in my own duty, I'm about to punt that question to Corinne. But my perception is that most stockholder plaintiffs don't view the demand route typically as a fruitful one for them to pursue, and I wouldn't think this would change that calculus, but.
Yeah, I think that's right. 220 is a limited tool, right? Sorry, can you hear me now? So 220 it's a very limited tool. It wasn't designed for discovery, and there is a pretty interesting discussion at the end of the March McDonald's opinion where Vice Chancellor Laster is talking a lot about non-responsiveness redactions. And, not only are you up against a limited set of documents, many of them are just well-crafted and drafted by very competent attorneys, some of which you see on this panel, that it can oftentimes gloss over the real details and the real nuggets of information you need as a stockholder plaintiff to pursue a good action. But not only are you up against that, but you're also up against the non-responsiveness redactions where a lot of companies are just carving out selectively pieces of those minutes that you're not able to see. Thankfully, Vice Chancellor Laster was talking a little bit about saying, there are real consequences to that. So at least from the stockholder perspective going forward, I think stockholders can get the benefit of either inferences in their favor. They may get conversion to a summary judgment in instances where there are over redactions. Maybe even full-blown discovery because the court just says, look, you're not giving all the information you should in response to a demand. So, in fairness, I think Vice Chancellor Laster was trying to balance the scales a little bit, understanding that 23.1 is a very powerful tool, but then also understanding that there are good claims to bring and you have to be able to get some information in response to a demand. So,
Vice Chancellor Will, I think, is gone, but I'm a big fan of her Amazon opinion where she said, yeah, you can redact for responsiveness because it's not not the subject of the demand. So maybe a fight that will be had in the future between.
you can do it just at your own risk.
Yeah. So Corinne, we will stick with you as we move to the exciting world of SPACs, but also the significant issues that they've seen and how the court has helped so far tens and possibly more, but billions of shares get fixed through Section 205.
Yeah, let me start a little bit off by level setting on what a SPAC is very briefly. These are publicly traded companies and they raise capital via an IPO and they have one purpose. That's to merge with a private company and take it public. And so when an investor buys into a SPAC, what they're buying is it's usually around $10 for a unit and then also a fractional piece of a warrant. The SPACs are usually formed by somebody who's called a sponsor or an entity called a sponsor, and the purpose of that sponsor is to go out and find the target. For the sponsor's efforts, they usually get a pretty big equity stake in the company that will ultimately be the company going forward. So it's 20% and a very small buy-in, something around $25,000. So what does that mean in practice? It really means that you have sponsors who are highly motivated to get a deal because they can get big returns on the end. Even on a value destructive deal, you can still make a lot of money off of your $25,000 investment so long as there's a merger that goes through. But remember, if there is no merger within 18 to 24 months, the IPO proceeds will go back to the stockholders with interest. So the stockholders who initially put money in, they get it all back. And the sponsor unfortunately loses out on any investment opportunity, and their stake is worthless at that point. But if there is a merger, then the stockholders can decide whether or not to redeem their shares or remain invested in the company. Admittedly, these investment vehicles, they are not as popular now. There was a big boom in right around 2019, 2020, even 2021. But recently, some are folding early due to lack of a viable target. There really are only so many good targets available out there, and there were a lot of SPACs. So some are folding up early. Others saw potential negative consequences coming out of recent tax changes. Some of that didn't really bear out, but there was some concern that maybe they couldn't find a viable target and could be subject to higher taxes. So in any event, the investing community kind of has moved on a bit, but unfortunately for Delaware, we are knee-deep in these SPAC disputes. But thankfully, we have Vice Chancellor Will. I'm sure she's exhausted from SPACs, so maybe it's a good thing that she's not here to hear this. But there is plenty to talk about in Delaware. Last year we were talking a lot about the multi-plan case, and just as a reminder, that was the first opportunity the Court of Chancery really had to apply fiduciary law to these SPACs. And it turned out that the application of that law didn't look a lot different than a fiduciary breach case, because remember, SPACs are Delaware companies, so they are still subject to the same fiduciary duties, and that's just something to keep in mind. The multi-plan case didn't go to trial. That actually settled for about $34 million, and it was approved last month. So we don't have much new to say on multi-plan, but Gig 3, that is the more recent installment in the SPAC story in Delaware. And that, I wanted to make note of that because it is like multi-plan. There were disclosure claims that were held to be viable at the motion to dismiss phase. But really the interesting thing about Gig 3 is how the court talked about why Corwin and MFW, where normally we think in fiduciary cases for your traditional corporation, Corwin and MFW are available to defendants when they're trying to get a case dismissed at the pleading stage, but not necessarily the case in a SPAC deal. And let me break that down just a little bit, because in a SPAC deal, the way that they are structured is that the economic interests are decoupled. So when you decide to either redeem your shares or to stay invested in the company, you don't necessarily have to vote against the merger. You can take your money out and then also vote in favor of the merger. And when you're doing that, you're actually incentivized to vote in favor of the merger, even if you redeem, because you still have this free fractional warrant out there that you can maintain your investment for free. Get your money back, still have an investment, so why not vote in favor of the deal? And so when the court looked at that structure, she said, MFW and Corwin don't make a lot of sense, because when you're thinking about applying Corwin and MFW, you want impartial decision makers who are economically motivated to make the right decision. Here, you don't have that in the SPACs transaction. There's ways to solve for that by recoupling the vote. You could certainly do that by saying that if you're going to redeem your shares, you also have to vote against the transaction. But in this particular case, that didn't happen. So that was kind of the update on the fiduciary side of things. On the statutory side of things, the most recent opinion out there was, or one of the most recent, is the Garfield versus Box decision. And that is really interesting because it was analyzing how Section 242 of the General Corporation Law would apply to a SPAC taking account specific charter provisions. Just a brief summary before we get to the Lordstown decision and open it up for more of a discussion. But the brief summary here for the Box decision is that the plaintiff was a Class A stockholder in a SPAC, and that SPAC had both Class A and Class B shares. The stockholders in that SPAC were asked to approve at least three things. The first was the transaction. The second was a charter amendment that would have increased the authorized number of shares of Class A common stock. And then the third was a charter amendment that would have altered the vote required for an increase in the authorized number of shares going forward. And so before that vote happened, a stockholder came forward, wrote a letter to the board and said, we need a separate class vote for the Class A shares under Section 242B of the DGCL. For those that are less familiar with 242B, it requires that classes of stock get a separate vote on these types of charter amendments. That's classes, not series. We're talking about classes. Company complied with request, held a separate vote for the Class A stockholders, and so counsel for the stockholder sought a benefit or sought a fee for the benefit conferred. So pursued a fee, and actually that particular counsel had represented a few stockholders who had brought similar demands, so there were a number of fee petitions outstanding. Boxed happened to be the first one that was decided. But in any event, this is where it gets really interesting, because the court looked at 242B, but then also looked at the SPAC's charter and said, you know, in the context of deciding whether or not the claim was meritorious when filed, and said, you know, whether the claim is meritorious really turns on whether the Class A and the Class B stock in this SPAC were actually classes or were they series of common stock. The court interpreted the SPAC's charter as saying that the company had authority to issue different series of preferred stock, but only different classes of common stock, and as a consequence found that the class was actually entitled to a separate vote under 242B. I will say that came as a real surprise to a lot of practitioners in Delaware and certainly beyond Delaware as well, because if you had asked anyone before the Box decision came out, I think the likely answer would have been if you have a Class A and Class B of common stock, that would be considered a series, not a class. But, you know, maybe as a consequence of the particular charter provisions here, the court came out very differently. And so the real impact of the Box decision is you had a number of SPAC boards looking at their charter thinking, oh wow, I think we might have a problem here. Hence the flood of Section 205 petitions, and that have been keeping Vice Chancellor Will extremely busy. But Blake, I know your firm has been involved in a number of these. Do you want to talk a little bit about how those hearings have been going and what they look like?
So what they look like now is very different from what they looked like in, for example, the hearing that led to the Lordstown opinion. Vice Chancellor Will, to her credit, has largely wrestled the beast into to a manageable size. The hearings are, so she will stack a number. She'll schedule a number of hearings in a single judicial session. Each one of them is taking somewhere around 15 to 20 minutes. So the petitioner gets up, does their presentation. They're not a lot of questions because most of these issues have been teased out, but she's still asking questions in individual scenarios. There are some that have received objections, and so she's dealing with objectors. There are some that have various twists, but thus far, every one of the petitions that has gone before has been approved, and the shares have been validated under the reasoning that the Vice Chancellor set forth in Lordstown. So that's really been the pattern for each one of these. But to her credit, she is giving every single one of these petitions its separate due, and objectors are getting their objections heard, overruled so far, but heard, and some of them have different issues. There are some of them are fairly cookie cutter, but every every day or so, there's one that has a twist, and so far she's been dealing with them all. But the court has, setting aside the SPAC days, where she just burns through them.
And I will say some of those objections, I think on a different day, in a different context, they would certainly be meritorious. Some in particular talk about, why not just have, just do a vote, because some of the excess authorized shares hadn't actually been issued.
Yep.
And so, why not use 204 instead of 205? I think there was one particularly colorful note that I think it would take one company about 117 years to even issue the authorized shares that they had. So, again, why not just have the vote? But given the context of the flood of petitions out there, and the real need to, even in the court's words, avert untold chaos, it just made a lot of sense to just keep moving forward and get these granted.
So one question, Corinne, I mean, this all flows from the Garfield versus Box decision. Besides every single SPAC that has the same charter amendment going through Section 205, is there any way, practical way to fix this issue?
Yeah, I think, well, look, I think what we have to do is give a little bit, or actually a lot of credit to the stockholders that raised the issue in the first instance, right? So one of the benefits of having an active stockholder base is that they act like real disruptors in the market, because they bring to the court's attention problems that, maybe transactional partners didn't see for years. And the nice thing is that not only are they able to do that in Delaware and bring it to the court's attention, defense counsel's attention, companies' attentions, but then given 204, 205, there is a mechanism to address it. And so, maybe that's the fix. Perhaps it could be more efficient, but I will say that the court was incredibly efficient with these 205 petitions, getting them, many of them knocked out within, a month of filing. So, sure, could it be faster? Yeah, but did it happen pretty quickly? Absolutely.
And I know Vice Chancellor Lasser has referred to this as a SPAC apocalypse. Based on what on your answer, there are some who might think this shows a flaw in the Delaware system, but your answer suggests you think it's kind of proof of how it is working.
I would say that exactly. I think it is proof of how it's working, because you have stockholders who have an opportunity to bring something to the court's attention. I think the one tough part about the Box decision is that it was brought in the context of a fee petition, which can be a little frustrating for practitioners, because what you'd really like to see is either something addressed at a motion to dismiss phase, or summary judgment, or a trial where you're dealing with a real meritorious standard. It's a little bit wonky when you're talking about a fee petition context, because there it's after the fact, the company's caved, the attorney says, I'm entitled to a fee here, I got a class vote, and I clarified a major issue. So, it's tough to look at it from that perspective, and you really do want a full decision instead.
Thank you. So we'll turn it to Rolin to talk about the match decision, which is, and Corinne and I this is why we're sitting so far apart. We are on the opposite sides of the match appeal, which is finished briefing, and we're waiting for argument. So we will let the neutral Rolin Bissell address match and the independence of special committees.
Although I'll note that there is no other plaintiff's attorney up here, so take all of this with a grain of salt. There is no counterbalance right now.
Well, everybody will be relieved to know that I'm not going to litigate the match case up here. I'm actually going to touch upon 2 points that were made by the prior panel, serendipitously. And that is, because they're raised both by match and another case I'm going to discuss, Trade Desk. And one is, I think you heard former Chief Justice Strine talk about, is it a good idea that we're applying MFW to transactions that are not the type of transaction that MFW was developed for, which is the controller freeze-out merger? And the second issue is one I think we heard Chief Justice Seitz talk about, which is hey, these independence issues are kind of hard, and maybe it's tough to decide them on the motion to dismiss. And these two cases, at least certainly matched us, shows how maybe tricky it can be to get into independence on a motion to dismiss. And I'll get to why independence directors is particularly important in MFW cases. Now, just to, again, level set, to use Corinne's term, what is MFW? I'm not going to do the 6 conditions, but originally there was a problem with freeze-out mergers by controlling stockholders. The controlling stockholder, by definition, has pretty good control over the stockholder vote that you need for a merger, and it has large influence on who's the board. So in terms of getting, traditionally doing a freeze-out merger, the court was suspicious of the controlling stockholder's motives when the controlling stockholder basically wants to buy in the company, because the controlling stockholder's interest is going to be pay as little as he needs to or she needs to buy the rest of that company. And that is going to be against the interests of the minority. And so traditionally, controller freeze-outs were examined under the entire fairness doctrine. Now, there was an idea like, well, is there a way you can get a controller freeze-out so it looks more like arm's length bargaining? Is there some procedures, what MFW calls conditions, that you can put in place where maybe the court could get comfortable enough that in reviewing a controller freeze-out that's been challenged by a stockholder plaintiff, they could apply business judgment instead of entire fairness, because entire fairness cases generally could not be dismissed at the pleading stage, which meant you're going to go through years of discovery and expensive trial and expert witnesses. So was there an off-ramp that maybe a transaction planner could take so they wouldn't have to do that? And what the court came up with ultimately was MFW. And it has 6 conditions, but the gist of the 6 conditions is really 2. It's having a special committee of independent directors who have the power, who do the work, that they can be an effective bargaining agent for the minority. And can you do the stockholder vote in a way where the controller doesn't have undue influence? So what you do is you have a stockholder vote where the majority of the minority gets to decide whether the transaction is going to be done. And there's also some things about it has to be an informed stockholder vote. So the idea is, because you've got this great independent committee of directors and you have this majority of the minority, you can get comfortable with the controller freeze-out transaction. Now, that template has been applied to other transactions involving controllers that don't quite look like a squeeze-out merger. And for example, in Match, the transaction was a reverse spin-off. Basically, they're splitting a company into 2, and the old stockholders, simplifying a little bit, are going to get stock in the new company. So it's not a freeze-out. It's something a little bit different. And the court noted, even though it applied MFW, that this doesn't really look like a freeze-out, but I'm going to apply MFW as well. And in Trade Desk, the transaction was the extension of a dual-class voting stock provision in the charter. It was going to sunset. The controller wanted it to go for a few more years for reasons. So it wasn't really a freeze-out either. And MFW has been applied to cleanse a number of different types of controller transactions. So if I were the inventor of MFW, I'd be saying MFW is this delicious ketchup you can pour on any transaction and it makes it taste better. It works on freeze-outs, it works on spin-offs, it works on exec comp. Use it in your next transaction, the court will find it delicious. And the question is, and this is what Chief Justice Strine was raising, is that really so? And I think it's something where maybe we should be a little more cautious about where MFW is being applied, because its conditions, MFW's conditions, don't always map easily onto the non-freeze-out situation. Sometimes self-dealing of a transaction with a controller is very easy to see. Other times, it's a little more difficult to see if the controller's receiving what's called a non-ratable benefit. And there's a lot, that neologism can cover a lot of different things. And I don't want to belabor it too much, but I just want to talk about a transaction type that came up recently where the court thought, well, you could have avoided this problem if you folks had applied MFW. And that's the CBS Viacom merger. There's a merger of two media companies owned by the Redstones. And both of the transactions got attacked as being unfair, even though they were a merger in which stock was being exchanged, and basically the stockholders of the old company are going to carry through. And in the motions, deciding the motions dismissed, there's a hint in both decisions that, if you had an MFW, you might have been able to get past a motion to dismiss here. You didn't, so you're going on to discovery. But when you start thinking about how do you apply MFW to a transaction like that, it gets real hard, real fast. Because MFW has what's also known as the ab initio condition. I think now we're just calling it from the beginning because we got sick of the Latin a couple of cases ago. But it means basically the controller has to get out of the way immediately. The controller comes in and says, I want to do the freeze out, but he's or she is not meant to be talking about terms or anything like that with the company because you don't want the controller to pre-bake the transaction. Now, try to apply this to CBS Viacom. I mean, it's a stock-for-stock transaction. Who is the initiator? Is it the controller? Does the controller write to both companies and say, I want you to explore this? Who is being squeezed out? Is it the CBS stockholders? Is it the Viacom stockholders? Who knows? Do both companies have to have a special committee? Do both companies have to have a majority of the minority vote? So when you start taking these conditions and you start applying them to different transactions, it gets really hard to see how to do it. And it's not a costless thing to apply MFW. I mean, it costs money and time to set up special committees, have these types of votes. And, there's a concern that by sweeping non-freeze-out transactions into the MFW rubric, in other words, saying, you can get business judgment if you do MFW here, you might be making it actually more difficult to do the transaction. So that is the MFW creep issue, I guess. Blake, you got any questions on that before I move to independence?
I mean, I know that former Chief Justice Strine has written an article, and we heard it again. But I mean, we are seeing it. We're seeing it all, in all different areas, and we're also seeing kind of the inverse of it, which is challenges where a stockholder plaintiff says, you didn't do MFW in this situation, so therefore you're stuck with entire fairness, even though it's a situation in which MFW had never been used before. But the very fact that you're not putting an MFW coat on it is somehow proof that the negative implication is you're stuck with entire fairness. So we're seeing it kind of in two different directions, actually.
I think the point we're missing here is that entire fairness, well, I'm sorry, we're not missing a point, but the point that I'll make is that entire fairness is the standard, right? So if we're talking about MFW as permitting a pleading stage dismissal, if you're not going to comply with MFW, then go to trial, go to summary judgment, go try to prove your case. And, look, Elon Musk did it in Tesla. Sherry Redstone did it in CBS. If you're not going to set up an MFW standard, then you stand by your transaction and you go to trial and prove why it's fair. But that's the default, right? So it's not that MFW is costly. MFW is actually a cost savings. That was why it was implemented. It was implemented to give people a path out. And so if you're not going to use MFW, that's fine, but just go defend your transaction in court.
I mean, one thing that I've seen is that plaintiffs have, in some cases, argued that the failure to use MFW itself was a sign of disloyalty. That, and Corinne and I, interestingly, are on the same side of the CBS Viacom case, because Corinne represents the plaintiffs in the CBS case, and I represented the members of the special committee on the Viacom side. So we were each arguing the same thing about the economics of the transaction. It made for kind of fun for us.
It's nice to be aligned once in a while.
Right. That's why we're on the same side of the table.
We're happily coexisting here.
But there were arguments in that case, at least on the Viacom side. I can't remember if you all made it in the CBS case, that the failure of the company to set up an MFW structure was itself evidence of the lack of independence of the members of the committee, and potentially a bad faith decision on their part not to take advantage of that procedural vehicle.
Yeah, but I think it's a fair point, right? It's not even that, it's not that you're not taking advantage of MFW, it's the fact that you're not setting up a special committee. It's that you're not permitting a majority of the minority vote. And those are important factors to consider when you're talking about how much control a controller had in any particular transaction. If that particular controller has so much control that nobody's even willing to put together a special committee or talk about forming a special committee or raising it, that's an important factor to consider, especially at the pleading stage and certainly at the trial phase as well.
We're getting short on time, so I'm going to jump to independence. And 'cause I don't think we're going to convince Corinne today, but I'm going to try again tomorrow, and then every day after that. So, because of the special committee, its effectiveness, its due care, and its independence are so crucial to getting the benefit of MFW, challenges to independence at the motion to dismiss stage, where there has been an attempt to set up an MFW structure and a special committee, are sort of a perennial issue that gets litigated. I don't think there's that much something that match trade and desk and match share is they both discuss the issue of, well, the independent committee, actually, not everyone needs to be independent. A majority of the committee needs to be independent. And in trade desk, this wasn't that much of an issue because the allegations that the directors on the special committee were not independent, were not particularly impressive to the court, at least from the opinion. That's the sense one gets. And the court just sort of says as an aside, well, even if this person wasn't independent, the third director wasn't independent, the other two were, and there's no indication that the potentially non-independent director influenced the other two, so this committee's independent enough. And the same result in match, although in match, the one of the directors the court found was not independent, and then had to do a little more discussion of whether the director influenced the other two and determined that it had not. And I think we heard Chief Justice Seitz talking about how close these independence calls can be at a motion to dismiss. Again, at a motion to dismiss level, the court's not meant to be weighing facts. If an allegation makes something reasonably conceivable, it's meant to be accepted. And so when we start talking about, and this has always been a tension in Delaware law, in that the court does decide what independence issues at the motion to dismiss stage. A fair amount, but usually it's in the context of, well, there's just not enough of an allegation that would make me doubt the independence of the director. When you start getting into a analysis at the motion to dismiss stage about whether a non-independent director influenced the other two, I think it gets even more difficult for the court to make that determination that the committee was independent enough. It takes what Chief Justice Seitz called a close call and makes it that much closer. So, the court, and certainly Metch, did dismiss the complaint and found that the non-independent director didn't influence the committee. That's up on a appeal, and we'll see how Blake and Corinne do. I'm not telling you who I'm betting on. I think Caesars is taking odds, but we'll see.
So, I don't know, maybe Gary, if you have a question, I'm trying to think of a question without any editorial spin, but finding it difficult.
Yeah. Well, I mean, to me, it's interesting as to whether the question is, in assessing independence, whether the individuals were independent of the controller or whether the committee was independent of the controller. And if the idea is to replicate arm's length bargaining as Rolin described for MFW, which of those do you think makes sense, or which has the court been focusing on?
I mean, from a planning point of view, and I'm going to do what you did with my question about McDonald's, is, MFW is, Corinne's right, MFW is a prophylactic that is, I won't say it's a gift from the courts, but it's for the right transaction, and certainly a squeeze out is the right transaction. It gives transaction planners and companies a way to do something for a lot lower cost than they could do it before. So why you would want any fuzz on your special committee when you are trying to get MFW, and you want to win on that motion to dismiss. You don't want to it turns out my committee was independent after trial. I mean, that's useless. That's useless. So the independent committee that has one person who's maybe not that independent, that just seems to me like, why go there? And I guess the answer is sometimes it's people who know the most about the company who have the most potential independence problems, and you may feel like you just need that knowledge to be able to negotiate effectively in the transaction.
It can be also, even if someone doesn't have the most knowledge about the company, someone who has the most knowledge about transactions. Yep. Generally, someone with experience in M&A, someone with experience in finance, you just may want to have that person on the committee because you think they will actually do a good job for stockholders.
And so the experience is one, and we heard from all three of the chiefs that independence issues are not necessarily obvious ones. So, if you could find someone who doesn't know anybody and doesn't know anything about any of these things, but to the point that may not be the best director to have on the committee. But if you find someone who has the relevant industry experience and has relevant M&A experience, but they've gone to a few weddings, is that enough? Maybe, maybe not. In Martha Stewart, it wasn't enough, but there could be situations. So some of these are not as obvious from the beginning. You could say, well, yes, I've known this person for 20 years, but I wouldn't jump off a cliff for them. So maybe that's enough. But and so it makes the bright lines harder because there's no bright line on independence.
There's been, I've seen this, and Corinne may have a thought on this, but over the years, when you get these interrogatory responses looking for information about independence, each time I get one, it's a little bit longer because there's been a recent case that found some fact relevant to independence. So I used to not see people asking about charitable donations or vacations or common plane ownership or whatever it might be. And each time you get a decision on non-independence, the plaintiff's bar will add another interrogatory sort of targeted at that particular issue.
Right.
Yeah.
In
And-
fairness, you usually find more information on the internet than you find in interrogatory responses, so.
Then we're doing our job.
Right.
Thank you.
But I think just in terms of a practical step you can take, I think we've also seen a lot of times people just don't rely on the annual director questionnaire. There's a supplemental independence questionnaire that goes to the directors that's focused on the transaction they may be looking at as a special committee member.
So I'll give, Justin, give me a couple more minutes and I'll bring us through the last topic and then we'll wrap up. So for nearly 40 years, Delaware law has allowed corporations to exculpate their directors from breaches of their fiduciary duty of care. We heard about that from the chiefs. But it has always only been directors and never officers. And for decades, that didn't really matter. As Gary noted, it wasn't until 2004 that Delaware law was amended to provide that certain officers of a Delaware corporation had consented to be sued in Delaware for breaches of their fiduciary duties. And then it took a while for plaintiffs to start actually suing officers as defendants. And as Gary mentioned, Delaware law had generally presumed and then expressly held that officers owed the same fiduciary duties as directors. That proposition, combined with their inability to be exculpated under 102b7, led in the last 3 or 4 years to some interesting results. Some might say odd and disturbing results, but that's a personal spectrum. For example, in the 2020 case of City of Warren versus Roche, an M&A fiduciary case went forward against a single defendant, the CEO. The loyalty claims were dismissed as unfounded, but because the proxy allegedly selectively disclosed projections and because the CEO signed the proxy, an unexculpated care claim survived, and the court noted that the CEO could be potentially responsible in quasi-appraisal damages for the entire merger, a merger that had been approved by the board and by the stockholders. All would, the entire liability would be on this one officer who signed the proxy. To address this situation, the Delaware General Assembly amended Section 102b7 to allow for the exculpation of officers in certain limited situations. It only allows for exculpation of claims for breach of the duty of care, like for directors, but unlike for directors, it does not apply to claims brought by or in the right of the corporation. In other words, officers are not exculpated for care claims against derivative suits. So the McDonald's case that Gary mentioned would not, a director would not be exculpated for a care claim in that context. There's limited amendment has been, I would say, fairly roundly criticized on the plaintiff side of things. Glass-Lewis, I think, recommends against in most circumstances. ISS is a little more case by case. So it hasn't. There are challenges to it. 2 companies that adopted such an exculpatory provision early on, Fox Corporation and Snap, have faced litigation challenges. And notably, both of those companies had multiple classes of stock. Fox in particular had 3 classes: high vote, low vote, and no vote. The high and low vote stock approved the amendment. The no vote stock was obviously not given a chance to vote. Plaintiffs challenged this amendment on the basis that Section 242 of the corporate law, 242 made an appearance in Box and an appearance in this in the Fox and Snap cases. So it's really having a moment. So their argument was that Section 242b2 mandated a class-by-class vote because the holders of the no-vote stock were adversely affected by the loss of some quantum of their right to sue was adversely affected because their right to sue no longer allowed for however big a part that is of direct claims against officers for the breach of the duty of care. The Snap and Fox litigations were consolidated, and after substantial briefing on the issue, the Court of Chancery ruled just last Wednesday in an oral ruling in the defendant's favor based on a 1942 Delaware Supreme Court opinion, a 1997 opinion from the Court of Chancery, and really long-standing practice, decades and decades of practice, finding that class votes were not necessary in this situation. I won't drag us through the statutory analysis, but I think it's fair to say that most of the court's oral ruling, maybe in the 90% range, was dedicated to demonstrating that the bases for upholding the amendments were actually flawed in many ways. And so I think everyone, I don't see the plaintiffs in here, but I think everyone is expecting an appeal. So watch this space next year for what Chief Justice Seitz ran off at the right time, so he'll be dealing with it soon enough, I guess. So I know Justin came up to wave us off, but I really want to thank my panelists. Corinne only had to go from here to here, but Gary came all the way down from Connecticut. So thank you very much. But thank you all.